Welcome to Accelerated Timelines, gathering evidence and making your case with experts for cases on the dedicated dockets, sponsored by the ABA Commission on Immigration. If you are seeking CLE credit, you must attend the entire program. Partial credit is not available. Please click on all the participation verification alerts during the program to confirm your attendance. Immediately after the program ends, a link to complete the certification process will appear. Please complete the evaluation and the CLE affidavit providing your bar information as requested. Once the completed form is submitted and your attendance verified, your certificate will be emailed to you. Moderating our program today is Emily McCabe. Emily is a senior staff attorney for the Family Group Legal Orientation Program in the American Bar Association's Commission on Immigration. And now, let's get started. Emily, welcome to the program.
Thank you so much. And I'd like to briefly introduce the rest of today's panel. Joining me on the program are Annie Dare, Dr. Lauren Heidbrink, and Dr. Stephen Symes. Annie Dare is a senior staff attorney at the Center for Gender and Refugee Studies, or CGRS, at UC Hastings. Annie focuses on strategic litigation, research, training, technical assistance, and policy advocacy to advance the rights of asylum seekers. Dr. Lauren Heidbrink is a legal anthropologist and associate professor of human development at the California State University, Long Beach. She is currently a visiting fellow at the University of California, San Diego Center for U.S.-Mexico Studies. And Dr. Stephen Symes, MD, FACP, is the co-founder and medical director of the student-run University of Miami Miller School of Medicine Human Rights Clinic for torture survivors and asylum seekers. And please feel free to read our extensive bios online, and they are included in your materials. And we will begin today's discussion. Annie, do you mind explaining what is the dedicated docket?
Sure. And first of all, just thank you so much for having me and welcoming CGRS to speak on the panel. And of course, thanks to my co-panelists. So the dedicated docket is an accelerated docket that the Biden administration created in May last year. Like other accelerated dockets that were put in place by prior administrations, the dedicated docket that we're speaking about today was created with the stated goal of addressing a backlog of cases pending in immigration court by setting a target completion deadline of 300 days from the initial master calendar hearing. The dedicated docket fast tracks the removal proceedings of families apprehended between ports of entry on or after May 28, 2021, who have been placed in removal proceedings and have been enrolled in alternatives to detention. So it goes without saying that 300 days is a very short period of time in which to obtain legal representation and prepare a removal case, which of course we'll be talking about today. But just to give a little bit more context on the docket, the Biden administration has sought to distinguish this program from prior rapid or accelerated dockets by emphasizing that the 300-day deadline is a goal and not a hard requirement, and by emphasizing the balancing of expeditious adjudication with due process and fundamental fairness. So for example, under the program, the immigration judge has to, quote, endeavor to issue a decision within 300 days. And the administration has said that families are to be provided with a number of services, including information services or access to information services and possible referrals for legal representation. And it has also said that it expects that immigration judges will make determinations with consideration of the respondent's statutory right to counsel and consistent with due process and fundamental fairness. But I have to start the program by saying that in practice, we have seen that the dedicated docket, like the accelerated dockets before it, has been just a real nightmare. The Transactional Records Access Clearinghouse, or TRAC, as well as UCLA's Immigrants' Rights Policy Clinic, which is part of the Center for Immigration Law and Policy, have both published reports regarding the implementation of the dedicated docket, and they've documented all kinds of problems most notably extremely low representation rates, very few people even filing applications for relief from removal, many in absentia removal orders, including those against children, and then various other just really egregious due process violations. So I want to be clear from the outset that we do not in any way endorse the dedicated docket. We are working with partners around the country to put a stop to it. And if anyone on this webinar is interested in joining us, please email me, and I'm happy to loop you in with folks involved in the advocacy effort. But that said, while the cards are really stacked against families on the dedicated docket, I just want to start by emphasizing that legal representation and the involvement of expert witnesses can make a huge difference in these cases. So with all of that said, I just want to emphasize that this is an area where representation really matters, and the assistance of experts is also huge. It's not easy to litigate these cases, but providing these services is just incredibly important, and probably the biggest factor which will increase families' chances of obtaining protection.
Thank you for that. And when should an advocate start gathering evidence for a case on the dedicated docket, do you recommend?
So unlike my answer a minute ago, very brief on this one, which is as soon as possible. Given the time frame, you want to start as quickly as you can.
Thank you. And can you share any creative ideas for gathering evidence on such a tight deadline?
Yes. Overall, I think big picture, I would just really try to front load the fact finding and evidence gathering as much as you can. So I'd prioritize really trying to understand the facts of the client's case, and then trying to narrow down the case theory so that you can start making an evidence list and then prioritize the evidence that will take a long time to gather. So for example, trying to identify early on the evidence that you need from in-country. So corroborating witness statements or birth certificates, marriage certificates, things like that can take quite a while to obtain. And so you'd want to know that early. Similarly, you want to think early about what expert evidence you may need to prove your case. And certainly build in time for things like mental health or psychological evaluations and consultation with country conditions experts. I'd also emphasize that, efficiency is as important as speed. And so to that end, with client interviewing, I would really emphasize taking a broad approach and investigating all potential avenues for relief early on, so you don't miss something and then have to scramble at the last minute researching a new case theory. Really important to use trauma-informed interviewing practices, and that will certainly increase the productivity of your client interviewing. And so on that point, the ABA Commission on Immigration has put out a really great report or manual on family group dedicated docket pro bono work. And so there's great resources there for working with trauma survivors and trauma-informed lawyering. CGRS also has resources available through our technical assistance program that can assist folks with trying to implement trauma-informed practices in your client work. And then I would also emphasize just explaining the process of immigration court and the dedicated docket so that clients have a sense of what's coming, and also why you may be asking them to do so many interviews early on, explaining the expedited time frame. And then also I would really advocate for integrating country conditions research along with your client interviewing, because it will help inform your interviewing and just make the whole process more efficient. As for country conditions research more broadly, CGRS actually has a practice advisory on how to do country conditions research that may be helpful to folks. We also have country and issue specific country conditions toolkits, a toolkit being a collection of sources and relevant excerpts on certain countries and issues, as well as universal expert declarations on a number of topics. A list of the ones that we have available are included in the handouts for this panel. And so I think that's a great starting point to sort of make sure you're not reinventing the wheel with your research. Of course, certainly reach out to colleagues who have handled similar cases. And then the last thing I'll say is that, sometimes with regard to evidence gathering, especially in this sort of expedited context, you'll have to just do the best you can. And you may not be able to get the best form of evidence that you would have wanted in another case. And so, for example, you may have a case that involved an attack on your client, and there may have been a witness, a friend may have witnessed that. So normally you would interview that witness, you would get a full declaration from them, they would sign it, and you would offer their testimony at the hearing. If that's not possible in the time frame that you have, you could potentially provide screenshots of text messages that may have taken place between your client and that person, and then have your client prepared to testify. So again, not a perfect world. I wouldn't advocate for that as a starting point, but you'll want to be creative and just do the best you can on the timeline that you have.
Great, thank you. And how does the Real ID Act impact evidence gathering?
So under the Real ID Act, credible, persuasive, specific testimony alone can be sufficient to carry the burden of proof, and it's important to remind the adjudicator of that. If the adjudicator determines that the applicant's testimony doesn't meet their burden of proof, the adjudicator can require corroborative evidence unless the applicant doesn't have the evidence and cannot reasonably obtain it. So the takeaway for dedicated docket cases especially is to remember that corroboration is sometimes expected. As advocates, we should proactively corroborate everything we can, and make sure to have an explanation of why something is not reasonably available in the event that it's something that you can't obtain. So using the same example I mentioned a minute ago, the friend who witnessed an attack on your client, you should foresee that the IJ, the immigration judge, may ask for a statement from this person. And so you'll need to either obtain a statement or have an explanation of why you couldn't do that. And so some reasons to explore might be that the witness is too afraid to talk to you on the phone given the security situation in their home country, or perhaps they're afraid that if they mail a statement to you, it will put them in danger. These are very reasonable explanations. You just need to document it. And you'd also want to be sure to prepare your client to testify about why these witnesses were not able to send statements. Yeah, and then you can also try to think creatively about other types of evidence that you might use to corroborate in the event that you're not able to get, again, the ideal piece of evidence that you would have liked.
Wonderful, thank you. And then what happens if you obtain evidence that is probative, but you obtain it after the filing deadline has passed?
I think there would be two options that you can think about. One is you could file a motion to accept untimely filing. So if you get evidence that's probative, you want to make sure to get it into the record, especially in the event that your client doesn't prevail and you need to be thinking about the record for appeal. So a motion to accept untimely filing is not favored in immigration court, but you can often show good cause. And so especially on this really compressed timeline, I think there in many cases will be good reasons why you weren't able to get something by the filing deadline, and you would just want to document that. So keep in mind, one caveat to the motion to accept untimely filing is you don't want to overpromise. So if it's a piece of evidence that you don't know for sure if you're going to be able to get, you want to make sure that you're not sort of raising questions for the immigration judge if you're not going to be able to get it. So I would just weigh the benefit of the piece of evidence versus the risk if you are not able to get it. The other thing that you could try is a motion for continuance. So again, the administration has set this 300-day deadline as a goal for completing cases, but it's not a hard requirement, and immigration judges still have discretion to grant continuances. We have heard that there are lots of immigration judges denying requests for continuances on the dedicated docket, but again, to build your record for appeal, you would want to make sure that you ask for the continuance, even if it's ultimately going to be denied, because that would be a way of documenting that you did have this evidence or you did have new facts that you wanted to explore further, but you just didn't have the opportunity.
Thank you. And now we're going to turn over to more working with experts. Annie, could you just walk us through the different types of experts in immigration cases?
Yeah, there's really no end to the type of experts that you may think about utilizing in your case. The main ones that we see and use regularly are country conditions experts, psychological or mental health experts, and medical experts.
Thank you. And we are lucky enough to have two experts with us today. Dr. Symes, what inspired you to use your medical expertise and experience to spend time also as a medical expert in immigration cases? And on what subjects have you provided testimony and or reports?
So, to tell the truth, I got dragged kicking and screaming and resisting every way by my medical students. So, just a little background, one of my responsibilities in terms of medical care, I'm not a community doc. I'm actually always have been an academic doctor teaching others, right? So, I do take care of disadvantaged populations here in Miami. I'm an HIV doctor. And so, in that vein, I've seen a lot of issues surrounding trauma, surrounding social determinants of health, surrounding populations that have been disadvantaged. And we've all seen that come to life in a very short time span with COVID, but there's a long track history of how diseases affect populations who are disadvantaged. So there was that clinical part, and then I actually had to teach that to my medical students and my residents, right, as a part of my duties in academics, is make sure they live that. So one day they came along to me because refugee issues and asylum issues were coming to the forefront in Miami. This was about 12, 13 years ago, and they said, hey, we should start an asylum torture clinic. There are other places in the United States which are doing this, where medical professionals work with legal experts in immigration to provide attestation. And I said to them, listen, we have a lot of other things we're doing here already. But they said, no, we can do this. We know you're busy, but we will screen all the calls. We'll form the partnerships with the lawyers. We've talked to other medical students in other institutions who've done this. We can do this. So I said, okay, let's try it. Tried it once, and 400, 500 cases later, we're still doing it. So short answer to your question, that's how I got involved in this process.
Wonderful. Thank you. And Dr. Heidbrink, what inspired you to use your ethnographic and anthropological expertise and research to assist as a country conditions expert?
Yeah, so I think also similarly kind of initiation by fire. In the late 1990s, I worked at a torture treatment center in Chicago. I was a case manager at the time. I interpreted in therapy sessions and medical evaluations. Most of our clients were asylum seekers, mostly from Central America at the time, but really from all over the globe. And so doing some training of volunteer psychologists and physicians about kind of what the legal process was and why having these affidavits, these declarations were so important. And so had a kind of unique vantage point of being an interpreter in a lot of these medical forensic and psychological forensic evaluations, and also in kind of ongoing therapy sessions and group therapy sessions with survivors. And so in the process, I also accompanied folks as they were going to court, right, and saw expert witnesses testifying, what worked, what didn't work, what types of questions they were asked, how judges interjected and kind of took over the courtroom. And so, I think it even though I had worked specifically in Guatemala for a decade, it wasn't until I went back for a PhD in anthropology that the courts would recognize me as an expert. So now I provide expert witness testimony primarily in cases of child abuse and gender-based violence, gang violence, and indigenous culture in Guatemala. And I think specific to your question about kind of what that looks like in the courtroom, right, or what kind of anthropological or ethnographic expertise offers, I think, what I tend to do is focus on the ways the law in the books diverges from everyday practices, primarily, in Guatemala. And so I think as opposed to other disciplines or other experts you might encounter, as anthropologists, we spend years working in countries of origin and doing observations, right, in police stations and courtrooms and government facilities for children and family, community, and life. So I can tell a judge, this is what a police station looks like. This is how women are treated in police stations as they're coming forward to talk about domestic violence. And so it's kind of through this work that I then came back to serving as an expert witness, and kind of putting those experiences into context for the courtroom and really trying to educate the court.
Great, thank you. And Annie, how can expert reports help prove the elements of fear-based claims?
So experts help adjudicators make connections between the facts and the law, and that can happen in a multitude of ways. But just to give some examples of, things that we regularly use experts' testimony for. For forensic medical experts, one example is they can corroborate an applicant's account of past harm by giving an opinion on, for example, whether the applicant's scars or physical manifestation of violence is consistent with the type of harm that they recount in their testimony. So they can document things like female genital cutting, and these things really go to whether the applicant suffered past persecution. And again, there's a lot more to be said, but I'll try to not go on too long. For psychological and mental health experts, they can establish the long-term impact of a traumatic event, which could help prove that the past harm that they suffered was severe enough to rise to the level of persecution. They can diagnose disorders such as PTSD, which would impact their testimony. And this is really important with regard to credibility. And again, going back to the Real ID Act, credibility is central to any fear of return claim. And so documenting the impacts of trauma can be really important for helping the adjudicator understand the applicant's demeanor, for example, if they have a flat affect, why that's normal and not a sign that they didn't suffer past harm. They can also explain the impact of trauma on memory, which again is really important for credibility concerns. Those are just a few examples. Country conditions experts can provide, again, lot to say, but to keep it relatively brief. One of the main things that country conditions experts can do is provide social, cultural, religious, legal, or historical context regarding an asylum seeker's or other person with a fear of return claim, their country of origin that might otherwise be difficult to obtain, or provide additional corroboration. They can help establish various elements of eligibility for relief, including nexus, particular social group cognizability, lack of state protection, internal relocation, well-founded fear. It really goes on. So for example, I know Dr. Heidbrink just mentioned documenting the ways in which the law in the books differs from actual practices in country. That can be incredibly important because oftentimes the government attorneys will highlight the fact that, for example, in Guatemala, there are laws protecting individuals against gender-based violence or domestic abuse. And so having an expert be able to say, yes, these laws are on the books, but in practice, they're not, they're not applied and they don't actually protect people, is incredibly important for showing a lack of state protection. It can also go to nexus by showing that the persecutor knows that they wouldn't suffer any repercussions for harming individuals in that particular social group of, Guatemalan women, for example. One other type of expert that I didn't mention previously is an issue-specific expert. So for example, a domestic violence expert could potentially explain the root causes of domestic violence, and that can also help establish nexus. For example, by showing that a primary motivating factor for domestic abuse is the gender of the victim.
Thank you. And Annie, in what specific ways or documents might experts assist in an immigration case?
Yeah, so of course, well, I guess going through sort of with the case timeline, one really important way experts can help is with sort of background assistance, answering questions, consulting. And I think it's really important when you can to bring in experts early to help sort of develop the case in the first place. So for example, you might ask your country conditions expert whether a certain fact pattern fits what they know to be the case in country, and they can help you identify, follow-up questions you might ask to try to really hone in on the facts of your client's case early on, especially where the timeline is really compressed, like in the dedicated docket cases. I think this type of assistance is incredibly important. Similarly, the next step, of course, would be an affidavit or a declaration from the expert. There are two kinds. You could have an individualized declaration that, that involves applying the expert's background knowledge to your specific client. And then there's also universal expert declarations, which, as I mentioned before, we have many available through CGRS's technical assistance resources. And on the individualized ones, those would be cases where you would need to find a specific expert for your case. And then finally, experts' testimony is another way that they can be incredibly helpful to your case. Not all experts will testify in every case, but that is another area where they provide assistance.
And for our experts, which, if any, of the evidence that Annie described, or any additional type of evidence, have you provided in immigration cases?
Yeah, so a few different things. I mean, I'm working on a universal declaration that Annie mentioned on child-specific harms in Guatemala. That doesn't take the place of more specific and tailored declarations, but that is a really, I think, good starting point to see what are the trends, what are the issues, what are some of the resources that experts are citing, and then go find those reports. I just want to echo the importance of talking with the expert early. I think in those initial conversations, we're looking at the fact pattern and the basis of the claim. Is that something that we can support, that comes out of the research or our own field work, and might help to identify other avenues, right? You all are the experts on immigration law, and as country conditions experts, we can give you some suggestions of what different types of social groups might be kind of useful avenues to investigate. I think too, directing attorneys to country conditions reports, like part of what we do is stay on top of the research. So there may be emergent issues, there may be new reports or articles or research that's coming out about a phenomenon that we can then direct you to. And certainly, I'm on Twitter, I'm following social media about what's going on in the country where I do research. So there may actually be community newspapers or local community reporters, right, who are witnesses to or reporting on things that are happening in specific communities. More typically, I'll provide an expert witness declaration that's tailored to the individual applicant's claim. So I'll get a declaration and then look at the fact pattern, right, and tie what I know, the research I've done, and other research and policy reports to that. Often I testify. It's mostly telephonic or using WebEx. I don't testify in every case. Sometimes there's just not time. Sometimes there are multiple experts, and if you only have a few hours to cover, so that may or may not happen, and you as the attorneys obviously make that decision. And then I've also, worked as a guardian ad litem for children in immigration detention, unaccompanied children specifically through the Young Center. So sometimes having a guardian ad litem for minors that are unaccompanied is a different type of expert, but that can weigh in on what's happening with the individual child and what's the context. So those are some of the ways that I've weighed in.
Thank you.
Yeah,
and
yeah. So we've gotten pulled into almost every different situation or medical. One of the interesting things that was mentioned was this idea of a medical affidavit looking for physical signs of prior abuse or torture, and psychological signs or psychiatric signs. And I'd have to say that about 90% of what we find, it's not physical. It's not the cigarette burn that has a classic diameter and depth to it. It's not a longitudinal whip mark as opposed to a thick scar. It's that's actually not the majority of what we see. It's really the psychological trauma. And in many cases, that exists outside or independent of what the clients are able to produce. They don't have a witness, they don't have a police report, or they couldn't file a police report, or they had to flee before they could pick it up. Um, so I think that's what we're able to do in terms of collect the history, document what we found in terms of past trauma, psychological trauma, and talk about how people are doing and what the context is. So a lot of times I get the question from people who've never done it before, medical practitioners who say, it's fine for you to do it. You're in academics, and and what I tell them is that, look, this is stuff that you do all the time as a medical practitioner. You get a history, you do a physical exam. As a primary doctor, you screen for signs of abuse and trauma all the time, right? And they're validated screens that are out there that you can use and utilize. And then you have to put that together in terms of this is what I think is wrong and why. And that's actually very powerful, especially when we document sort of how we've done it. Um, One of the really interesting, of the 400 cases that we saw 17 individuals who had been on this repatriation flight, right? So to Somalia. So, the federal government got together all of these individuals that they want to repatriate to Somalia back in 2019 and loaded them on a flight, 90 of them, just before, again, Christmas. They were chained at the wrists. They had belt chains and ankle chains, and they were put in the seat and flown, you know, intentionally. Right? The idea was to, fly them from Louisiana, where one of the detention centers was, to Somalia. Landed somewhere in Senegal for refueling after an 8-hour flight. Many of these individuals, again, had PTSD, depression, hypertension. Some of them had diabetes. So they're running low on their medicines. There's not too many resources, right? And then the flight sat on the ground for 30 minutes, an hour, 2 hours, 6 hours, right? We still never found out why. But 24 hours later, right, as the toilets were starting to overflow, the food was running out, there was no more medications for the people who had medical issues, right? They're getting cramped from these forced positions, right, that they were put in. A melee broke out, and then the 30 agents or whatever that were on the flight started to toss people around left, right, and center who couldn't fall properly to protect themselves because they're chained at the wrists and at the so and then the flight had to come back. It came back to the US, where a lot of the individuals ended up at Chrome Detention Center or other detention centers here in Miami. And a few days later, me and a couple med students went to interview people, and we got the same story over and over and over again from the 17 people that we interviewed. It was exactly the same. So there's your credibility, right? Yes, we were chained like this. Yes, we were positioned like this. Yes, we were tossed. We got to do the physical exams. A few people had scars, but most people actually had psychological stuff, right? Flashbacks. They had depressive symptoms. They had PTSD symptoms, right? So that's actually, one of the examples that we were able to put together. And most of the individuals actually ended up getting immigration relief, not for stuff that they had been seeking asylum for years and years and years, but the lawyers were actually very creative in saying, look, right, there was actual mistreatment and deviation from what you should have been doing, in terms of, appropriate custody process and so on. So again, that's an example of one of the cases where the champions actually, I thought, were really the lawyers, because when we walked into the detention center to go see these individuals, you know, Chrome Detention Center was fine, but there were some other ones out in the boonies of Florida. Glades Detention Center is about 2.5 hours drive away from here. Terrible, really awful. It had a contract from ICE to provide detention services, but it was not a standard federal detention center. And I was actually scared walking in there, right, by the way that the detention officers were, you know, carrying on and so on. And the lawyer actually said, listen, you guys toe the line. You have to do this. I have an order, a court order, that you have to treat these people properly. I was actually really, really impressed. And even more than that, my students were like, wow, right, I want to be like her. Right? So again, it to talk about scary and intimidating for what the clients go through, it's really minimizing a lot of the stuff that they've been through, not just at the border, but when they're detained, and then the other stuff that happens. And again, as medical practitioners, we're uniquely suited to doing that history, that physical, putting together the assessment and saying, this is what's wrong and why. So
Thank you for that impactful story. And how do you typically find experts?
So there's a few different ways. Obviously, we start with internet research. A great shortcut certainly is to talk to colleagues who may have recommendations, and to reach out to folks who have provided this kind of similar services in other cases, and have a track record, that where someone can tell you, for example, that the person followed through, and how they were to work with, and that sort of thing. The other thing I would mention, which is a great shortcut or starting place, is CGRS's expert database. So this is a database that we launched, I think, a couple of years ago, I should know, that allows attorneys to search profiles of, I believe, more than 300 medical, mental health, and country conditions experts. So through the database, you can find various experts' CVs, their areas of expertise, including certain countries or certain types of issues, in the case of country conditions experts, but it also includes all kinds of detail on forensic medical and mental health experts. There's also information on whether that expert is accepting new cases, as well as their language capabilities, and whether they're willing to testify in court. So I would plug it as a good starting place for anyone looking for an expert in your case.
Thank you. And when I was in direct services, that was I used that all the time. Definitely the gold standard.
Great to hear.
And for our experts, how have practitioners found you in the past?
For me, it's been really varied. I think because I, as I mentioned, worked at a torture treatment center in the late 90s, and kind of plugged into that network. And so folks that may have a case that comes forward, they've kind of worked with me in the past in different capacities, or even clients there, right? Or other members of the Guatemalan community who say, hey, my nephew's here and he doesn't have a lawyer. Can you help him find a lawyer? And in the process, providing an expert declaration to support that case, often because it's going very quick, and sometimes clients are going pro se and don't have time to identify a lawyer and get representation. Sometimes it's from community members in Guatemala that says, hey, my cousin's detained in that same Louisiana, right, detention facility, and is stuck. Like, can you help? And that is one way in which I can help. More typically, I'd say for other experts is through the CGRS, the fabulous database. Sometimes attorneys will just kind of send a cold call or a cold email saying, I know that you've done work on this particular country. Would you be willing? And if I'm not or able to, or it's not a good fit, I'll make other recommendations of other people. So sometimes it's word of mouth. And I also think there's a lot of academic kind of professional associations that are starting to do this work in more earnest and with more coordination. So you could look to something like the Latin American Studies Association that has a working group on expert witnessing in immigration proceedings. And so you've got academics from all over the globe, right, that are working in Latin America that are willing to do this work, or the Guatemalan Scholars Network. So identifying those professional associations is also a way. But I would, definitely support the CGRS database as the first place to start. And then if there are pro bono coordinators or nonprofits that you're working with, right, reach out to them and say, who have you worked with in the past? Who's been good, right? Just because we're experts doesn't mean we necessarily make for good experts on the stand, right? So communicating with those that you're seeking mentorship certainly can provide you with names and suggestions of where to start based on your country conditions. I'd say, in addition, just kind of thinking about who you're representing, right? So if you're representing a Central American, there's probably more Central American scholars who've been doing this work for longer. If you're representing somebody from Afghanistan, there are fewer country conditions experts, fewer people that have experience doing this work. Many of us are happy to mentor them, even if we're not country condition experts in that particular country. We're happy to mentor them on the process of putting a declaration, give them samples, those types of things. So I think that there are different ways that you can pull those together. All of that requires time. So I do think identifying that expert super early in the process and engaging them early is absolutely critical to finding the right expert to fit the merits of your case.
Yeah, and for us, the request for medical assessments comes from lawyers for that's 99% of the requests that we get. And the classic, groups that we get, thinking about, again, all politics is local, right? So locally here, the groups that always reach out to us are Americans for Immigrant Justice. It used to be called Florida Immigrant Advocacy Center, but about a decade ago, they switched their name. And again, they're a national organization, but they have a headquarters here in Miami, Miami-Dade. They were the first group that reached out to us for medical, doing a medical affidavit. There's Catholic Legal Charities, again, another group of lawyers that, again, focus on this idea of advocacy for both children as well as adults. They do a lot of work actually focusing on child immigration issues. University of Miami has an immigration law clinic that has different branches. One is for asylum torture, but they also do focus on things surrounding housing, climate change, and other sort of advocacy. But again, the law immigration group reaches out to us for attestations, and then there are local lawyers who figured out from networking with these groups that they should reach out to us if they need a medical affidavit. So that's what we end up doing. And our practice actually had shifted over the last couple of years because of COVID. We used to do all of our assessments in person, and now most of our assessments, I'd say 98% of them, are actually online through Zoom, because, again, of the restrictions. But we never slowed down in terms of the assessments that we were doing. There was a question that actually came up in the chat here, that our country and medical experts generally compensated financially. So one of the things we decided early on as an academic center, since we set this up to teach students and residents, we decided very early that we were not going to accept compensation for any of the work that we did. It was going to be a teaching academic exercise. We also put that in our medical affidavit that as medical experts, we do not accept compensation, and that we therefore are doing this on a less subjective basis, I guess. We're not skewed by that. So again, that's one of the things, again, that we set up for our individual clinics. So.
And I think if I can jump in to address that question, it really varies, right? I think academics are pretty divided on this. So there are many of us that do this pro bono, particularly with nonprofits. there are folks that charge money to do the declarations, and I think the argument for that is that attorneys in these large pro bono firms or large firms are getting paid as well, so paying academics for expertise is legitimate, right, as it is in other areas of the law. So that's something it's in the CGRS database, and is information if they're taking pro bono or compensated cases. Oftentimes people are doing a healthy mix of both, or if they're working in partnership with a nonprofit, right? You typically don't charge unless there's funding that they have gotten specifically for experts. There are some small pots of money to do that, to demonstrate that this is work that we do on the side, right? So I think for a lot of experts, we are full-time teachers, we're full-time researchers, we're full-time parents, and then this is kind of volunteer work, right? Our universities don't see this as part of our job or as valued for tenure, and so for those academics in those types of contexts, we can only take so many, right? So many at a time. So again, I think it really varies based on the expert, and then just a conversation to have early on.
Thank you. And what generally should be covered before an attorney and expert agree to work together on a case? If you could start us off.
I can go ahead and start, and I'd welcome additional thoughts, certainly of our two experts that we have joining us today. But what I would be thinking about it as an attorney. Well, I guess so. I have one comment in response to the question that we were just discussing. So I'll say that first, and then I'll answer this one. And my only additional comment is that I think there are really strong arguments for lawyers to make that even if an expert requires payment for their work, that's not necessarily an indication of bias. Experts get, there are very high expert fees that certain experts will pay in all different kinds of litigation. And so, just reminding the adjudicator of that, and that it's not necessarily an indication of bias, I think can be really important if you're in a position where you do need to pay your expert. So just one quick note on that. And then, yeah, in terms of, an initial conversation or initial issues to cover with an expert, when I'm sort of starting that discussion, I like to talk about sort of the scope of work, the specific issues that I would be looking for the expert to address, and then also discussing the respective roles. So the role of the attorney in the relationship is really to identify what is relevant for the expert to address, because we don't expect our country conditions experts or our forensic medical experts to be experts in the law. That's our job. And then also to provide whatever information the expert needs to be able to do their job. And so the role of the expert is to analyze the information that they have, potentially to do their own investigation as needed, and then to give a factual opinion and not a legal conclusion. I would also be discussing with the expert their experience and qualifications to ensure that they have the relevant background knowledge that they need to be considered an expert by the court. And then I'd also be asking whether the expert's qualifications or their prior reports had ever been challenged previously. I would want to know that as a lawyer. It doesn't necessarily mean that you wouldn't work with them, but that's definitely something you would want to know at the outset. So you'd want to ask, has it been challenged? Has your testimony ever been excluded? Or has it ever been given limited weight? And just get information on that. And then in terms of process, I would want to have, I think, Dr. Heidbrink had mentioned this earlier as well, really making sure to start early and building in time for internal deadlines, for example, for me as the attorney to give the expert what they need to do their job, and then also internal deadlines for example, an evaluation of the client in the case of a forensic medical or psychological evaluation, and then time for draft exchange to make sure that, feedback can be given, and to ensure that the final report is as strong as it can be. You'd want to confirm that the expert will accept feedback on the draft, and certainly not to say that the lawyer would be writing the report or giving that kind of feedback. But one example is a lot of times there will be information that's included that is not understandable to the judge because it's in medical language, or there may be issues that are covered that are really just not relevant to the case. And so you'd want to make sure that you will have an opportunity to collaborate with the expert. The other thing is you want to make sure that the expert report doesn't conflict with other evidence in the case. And this, especially on a compressed timeline, can happen where, for example, you have initial interviews with the client, you might give an initial draft of a declaration to the expert to give a sense of the background of the case. And then over time, through further interviewing, the facts of the case, as you understand them, have changed a bit. So you want to be really careful to read any expert report that's going to be submitted to the court, just to ensure that the story is clear and that it doesn't create credibility issues unnecessarily. Also, I would make sure to cover any language needs. So if an interpreter is needed in the case of the situation where the expert is actually doing an evaluation of the client, and then arrange for an interpreter as needed. And then I also would make sure to address whether the expert is willing or able to testify in court. As Dr. Heidbrink mentioned, in almost all cases, the expert will be able to appear telephonically if they're going to testify or via WebEx. But you have to make sure that you request that from the court. And so you want to be respectful of your expert's time and make sure that they're not going to have to appear in person if they are not able to do that, or if it's really burdensome. And then finally, cost. So we just mentioned, you want to make sure that you can cover the costs that the expert charges, or you could find out whether they are able to do pro bono or low bono. That's another option. Some experts offer like sliding scale fees. So depending on whether you are providing pro bono representation to the client, if you work for a nonprofit, those sorts of things, or if the client has greater means or lesser means, they might charge a different amount.
Any additional thoughts from Dr. Heidbrink or Dr. Sims?
I mean, I would
Go ahead,
say
Dr.
that, yeah, sorry. I would say that, to summarize what you said, is really to make sure expectations are clear between the two, right? Is a good summary of what was just said. And that's also important, especially if you have deadlines that are coming up quickly for court or so on. You want to make sure, again, you get all the evidence in that you can. The one thing I would say is that I've never had to actually, I mean, I think, and most people who do this should know, I've never actually had to testify in person or even telephonically that often, or online that often. It's happened, I would say, maybe in about 5% of all the cases that we've done, where we've actually been asked to be there in court. A lot of times the court will accept the written documentation as acceptable and so on. So that was actually something that was really interesting, that we weren't asked to come in or required to be there more often. We're willing to do it. It's just not been an issue. And I was only challenged once, and that was by a judge who felt like, as a primary care doctor, even though I do a lot of trauma-informed care, he didn't want me to talk about the psychological, uh, um, screening and assessment that we did. So, that was his prerogative, I guess. But yeah, he didn't want to hear from me based on that, right? So.
Just to chime in, I think one of the things that, it's up to the attorney to decide, are we a general country conditions expert, or are we an expert on something specific within the country? And I think there are pros and cons to both of those. And so I think in those initial conversations with experts, to see what's your experience and what have you been identified as an expert of, right? So you may come to me and say, can you, testify to X in Guatemala, but if I've testified in dozens of cases in Guatemala, but not to that issue, then I might not be qualified. So part of that initial conversation is getting to know each other, getting to know what the expertise, and if the expert's experience matches the claim, the basis of the claim that you're making. I'd say the other thing, particularly early on in preparing experts for doing this work, is having a really kind of honest conversation about the fact pattern, right? Because there are some cases that I've turned down or not provided declarations because the fact pattern isn't something that I can testify to in court. And so I'll tell the attorney, this is my experience, this isn't lining up for me. Doesn't mean it's not true, but if I'm on cross-examination, I'm not going to be able to testify in a way that's going to support your client. So it's up to you if you want to continue. An example of that would be, I particularly because I work with children, and I think the roles and kind of social position of children in Central America may kind of shock American sensibilities. That oftentimes there's this culture clash, right? Of like children that are 8 years old should not be working in the field. They should not have a machete. They should not be doing these things. That's abuse. That's child abuse, or that's child neglect. And I have to explain, no, in cultural context, it's not, right? It's the difference between survival and not surviving. And if you don't learn how to use a machete well at a young age, you're not going to be able to provide for yourself and your family. Your family's physically going to starve. So it's not a form of abuse, but there is a scaffolding process that happens when parents and grandparents are teaching children how to use these, farming equipment, right? Or that they don't use pesticides because that's seen as something for older teenagers. And so if the attorney's unwilling to have that conversation or that's, and I understand, right, they're like grasping for how can I make this claim, right? How can I be the kind of zealous advocate for my client, and there's not much to work with. I also need to be honest about what I can testify to and what I've seen in my research. So that's a really important, I think, conversation to have early on. I think specific for the dedicated docket cases, I'd actually really recommend you work with somebody that has some experience, right? I think the learning curve is huge, and to have to kind of coach and mentor an academic to get up to speed for this different type of writing. We're not trained to write well, period. But then we're not trained to necessarily write for these types of declarations. And so I think, again, the learning curve is huge. And if you've never testified in court and you're planning on using your expert to testify, again, having that experience to be able to very quickly explain why I'm being paid or not being paid, right, and bias or not bias, and to be able to say, look, this expert has testified in 5 dozen cases on child abuse in Guatemala. Will you stipulate to her expertise to move the case along? Those things are always, I think, very helpful in a dedicated docket case where things are moving really, really quickly. Again, if you don't have that luxury, find somebody and call in other experts to help mentor them. But I think working with somebody who does have some experience, given the abbreviated timeline, is important.
Thank you. And kind of in that same vein, any specific preparation or support you think that experts need on dedicated dockets?
For me, I think a lot of the preparation of support comes from the lawyers, actually, where they'll actually say, listen, this is a VAWA case, or it's an issue surrounding someone who's been a victim of human trafficking, or someone who got married here and then the spouse refused to provide, support for their green card application or whatever, or, so I think that part, that twist of what is it that you're looking for is actually really, really important. Did you want to talk a little bit more about that, maybe?
Yeah, absolutely. Just to echo that, I think that having even if it's a draft declaration from the applicant is really helpful. I've been approached by attorneys who have only inherited the case, or they've never met with a client, or they're just at the initial stages, and it's great to engage me early but I actually don't know what the facts are, so I'm not sure if I'm the best fit. And every expert's different, right? I only take cases in regions in Guatemala where I've worked, where I've actually visited and been. Other experts will do the whole country. And so it really depends. So I think that even if you have a skeleton of the fact pattern from the client and interviewed the client at least once, that's really helpful, as Dr. Symes was mentioning, just to kind of clue us in and help us to narrow down and focus our efforts.
Yeah, I would just reiterate that I think the best thing you can do as a lawyer is just try to do as much of the homework as you can for your expert so that they can do their job, and try to get it done as early as you can. Certainly you'll want to manage expectations that, as Dr. Heidbrink just mentioned, if you have only had a couple of meetings with your client and you're not totally sure of the facts, you'd want to make sure your expert knows that so they're not spinning their wheels on something that is not going to turn out to be the, thrust of the case. And also, let them know that the facts may change, the case theory might change a little bit. But to the extent you can, as I mentioned earlier, trying to really front load the fact finding and the client interviewing so that you can give your expert time to integrate that into their work, I think will make a huge difference. And then, just like really good open communication with the expert, check in and just ask them what they need. And I always try to just put myself in the service of the expert. So if they need more context, if they need more facts from me, if they want to look at the client's declaration, if they want to see my brief and my legal arguments, like I try to be as open as I can with them so that they will have whatever information they need to be able to do their work.
Wonderful, thank you. And then the last section we're going to cover today is reflections from the experts. And first, could you walk us through a case from your perspective? And we can start with Dr. Heidbrink.
Sure, and this is just kind of the nuts and bolts of how does this work, right? So initially, I'll get an email from an attorney saying, we've got bare bones facts of a case, would you be willing to serve as an expert? And I'll have an initial phone conversation, learn more about the case, share more about kind of my expertise and what I could bring to a case, and if it's a good fit, having that conversation. Oftentimes, firms, right, that are taking on the case through a nonprofit will want to do a letter of engagement. Some nonprofits do it, some don't. But again, just kind of setting out the terms, confidentiality, any fees for the declaration and the testimony. So most of the time I do that, but it's really up to the firm or the pro bono organization to do that, to have it in writing. And then I actually ask for a copy of the declaration, even if it's in draft form. I will go through and insert comments and questions. Knowing the context, knowing how I might be able to substantiate certain facts in the case, I might ask for more clarification. This I think also, particularly because I work with indigenous Guatemalans, oftentimes attorneys, one, don't realize that they're indigenous people in Guatemala, or if it's their first case, right, or if they don't really know much about Guatemala, or they don't realize that the client's first language is not Spanish. Right, and the client is not speaking up to say, look, I speak Mam or I speak Quiche. And so that's a question I ask, I'd say 9 out of 10 times, and attorneys typically have not asked their clients. And that changes the game, right? Sometimes I think the attorneys are interviewing clients and there's just some disconnect, and it's oftentimes linguistic. Not always, but oftentimes it is. So those are the types of things that come out, and that actually is helpful to me to say, okay, is this a gender-based claim or is this a gender-based claim because a woman is indigenous, right? And that's a very different intersection and different type of declaration that I would write. So then I'll come up with a draft of the declaration. I'll send it to your attorneys, or they'll get back to me. They'll get back to me with any responses to the question. Everybody's different. I typically don't want to engage with the individual unless I know them out of context, right, out of the legal process, and ask these questions directly. As Dr. Symes mentioned, folks are highly traumatized. Oftentimes, There's intergenerational trauma, there's war trauma, there's migration trauma, there's detention trauma, right? There's trauma of inequality and racism in the US that they're experiencing. I don't want to be yet another person, yet another white woman, to be honest, interviewing folks about their experiences. I'm going to trust that the attorney has a more trusting and closer relationship with their client. That said, there are some instances where I will speak directly to the client because there's something that's not matching up, or maybe I've been to their hometown, or I work in this particular region, and there are questions that really we need to connect. Typically, again, I try to avoid being yet another person asking intrusive questions. So I'll write my declaration, send it to the attorney. The attorneys will redline or insert comments. I'll do the back and forth revision. And I think explaining to experts when you need those benchmarks by, sometimes experts don't remember that there's special filing dates. Sometimes judges ask for things in different timelines than they're allowed to. So just being clear about when things are due, and if you need, for example, something to be a wet signature or a notary, providing them with court dates early on so we can block our calendar. If I testify in a case on the East Coast and I'm on West Coast, right, I'm up at 4 in the morning, so making sure I'm blocking the time. So I'd say that's the kind of general kind of nuts and bolts of that. And I would say for attorneys, just to be sure that you're using a professional interpreter, not a family member, not a child, not a spouse. There's also a lot of distrust within communities in diaspora, and so having a neighbor come and interpret may not also be a good solution. So really following the lead of your client, I think in all circumstances. I'm sure Dr. Symes can speak more to that, but yeah, so that's just the kind of nuts and bolts from my perspective. Oh, and sorry, one last thing, testimony. So I know that some experts are like, I've been doing this for years, I don't need prep. I love prep. Even if it's just an hour, right, that we've gone through, we're on the same page. I know how you ask questions. I know what you're going to ask, and we've prepared, I think just makes for a more kind of seamless and a stronger case. So again, some experts don't want to do it because we've done it so much, but to be kind of have communication with your expert about what they expect.
So I'll tell you, I guess, about a case. It's actually 3 cases that we saw over 3 weeks, and it's 3 cases because it's a family member. It's the same family, right? So if I had to label it or tell a story about it, it would be Nicaragua, 2 daughters and a mom, right? Because that's actually how it kind of turned out to be. It was the first client that we saw was the youngest daughter. She's 17. She had just started college actually, and 2 weeks into college, something happened. She was approached by 2 individuals as she left. As she entered the bus to travel back to her domicile, and they challenged her and said, "Hey, listen, we know that you don't support the government, and you better watch out. You better start towing the line, attending student organizations, going to meetings, and voting, or else," right? And so she ran back home, called her mom, told her this, and this just freaked the mom out. And within 3 days, she had packed up the youngest child, Catherine, the middle child, who actually was in her last year of law school in Nicaragua, also, and who is 21, and the mom, and they all left, and they're seeking asylum here in the United States. The interesting thing is that we started with the youngest, who again gave us some background on what was happening, that she was just scared and petrified, and talked a little bit about what had happened, you know, and what was going on in the country. We talked to the middle daughter the next week, who actually was able to give us a lot more detail about the background of what had been happening in Nicaragua from the time she entered law school, from what she was allowed to discuss in class to what she was not allowed to discuss, from the fact that, you know, they knew, you know, whether or not she voted, right? And would come and knock on her door and say, listen, you didn't show up for the last election in November and vote, and that's wrong, and you know, you're not meeting expectations, right? So even if you decline to vote, that's now not something that's allowed in Nicaragua, right? That you can be targeted and persecuted. And then the following week, we talked to the mom, right? And again, who kind of mirrored this and the fears that she had for her daughters. So there was no physical violence, but just digging into the stories, each individual story each week, you got the picture of how Nicaragua had changed. Not from me reading about it, right? Because you know, you'll hear about this on the news and kind of blanket, but from the perspective of these three women, from youngest who just knew she was really scared after 2 weeks of college and didn't want to the middle, you know, child who the second one who realized again all of these things have been happening in our country from 2018. She was able to tell us when there was an uprising surrounding social security benefits and how the government had decided that they were going to cost cut, to all the challenges that came out of that, to all the restrictions, to the mom who was able to give us even more context on what their life was like and what her fears were like for her children, right? So that's an example again of just collecting the story, listening to the story, making sure it's internally consistent, right? All these women were saying the same thing, but in a slightly different way from a different perspective. The first youngest was incredibly sad at leaving her grandmother and her boyfriend, and you know, missing that part, but at the same time completely relieved to be in the United States and, you know, not facing again that threat, that immediate threat. The middle daughter was just glad to get out, right? Because she'd gone through more and seen more and was less protected. And the mom, again, you know, just a completely different perspective. Listen, I could not put my daughters through what I've been through for the last 5, 6 years, was kind of the message that we got from her. And I couldn't be assured that they're going to be safe anymore. So again, that context and putting those three stories together over 3 weeks was actually really powerful for us to see, and spoke a lot in terms of credibility and in terms of what has been happening in the country, in Nicaragua, which is a democratic country, but with democracy slowly being curtailed to the point where, again, you know, it's, you have to vote, right? You have to vote, right? So, and very similar to what we've seen actually in other parts of, in other places like Venezuela and so on. So again, I think this is actually really important. And when you run through the depression and PTSD screens, kind of seeing where they are at this point in time is actually also very powerful evidence in terms of submitting a medical affidavit for these clients. So that's my story of Nicaragua: two moms and a, or two daughters and a mom, right? So.
Thank you. What a great way to illustrate it. And Dr. Symes, could you tell us about a bad experience working with an immigration court case? Basically, what maybe an attorney could have done better in your experience?
Well, I've not been disappointed by any attorneys actually. Every now and again, when we do a medical interview, for which for us is very personal, right? We actually have to meet the client and talk to them and see what they look like and see their expressions, and that goes into our affidavit. This kind of what's happening, what's a back and forth that we're getting, right? Which speaks to credibility and believability and consistency. So that's very, very important for us as medical practitioners. We pick up stuff obviously because we pick up stuff sometimes that the attorneys don't pick up, right? We'll pick up details about rape, details about abuse, will, you know, details of other things that are happening, physical exams, signs and symptoms. Oh, you actually ended up in the hospital 6 weeks ago. Let's go back and take a look at the medical records and see if the case managers or the social workers also documented it, or 2 years ago or 5 years ago, right? So, but that's stuff that we're trained to think about and do, right? We want to see that and develop that timeline. My disappointment sometimes has been actually with some of my experiences with the judges, right? So some of them have been incredibly positive. We had a client who was LGBT, um, who was just scared to go back to his home country, and the lawyer warned us left, right, and center going into court that you know the judge may not accept this. The prosecuting attorney that they knew well was going to attack me on this, and on this idea of you know um, trauma or persecution based on their LGBT status, and the judge shut the prosecuting attorney down like that, right? Just as soon as they started to try and attack me and the client who was also there in the court, right? They wouldn't allow them to push it, right? And so that actually was a very positive for me. A negative experience was with the judge that we had, where we had a client who'd gone had a tremendous amount of post-traumatic stress from being detained in Mexico and tortured in Mexico. And the judge wouldn't allow me to talk about it. He said, no, you're not. The lawyer, the prosecuting attorney said, or the DA said, you know, you're not a medical expert, Dr. Symes, in psychiatry or psychology. You can't talk about this. And the judge said, yeah, you can't. Don't talk about that. Talk about medical stuff. So again, it's been very positive, I think, for me overall. And just don't take it personally. That's it, right? So as a message.
Yeah, I guess negative, I've had snippets of negative experiences. I think, I've had the experience where attorneys in a small shop, right? I am doing it pro bono. I upfront say you cannot charge the client for your interactions with me if that's the conditions of me doing this pro bono, and then charge the client. I later find out. I've had the unfortunate experience actually testifying in court and then being in the hallway with the client and overhearing the attorney instructing the client to lie on the stand. So I had to report the attorney to the ethics board. That was not a fun process. Thankfully, those experiences are few and far between. And I think similar to Dr. Symes, I've had experiences in the courtroom that have been really challenging, right? Judges that take over lines of questioning. I've had judges say, I don't want to hear about things that are systemic, right? I don't want to hear about patterns. And it's like, well, that's the whole, like, this is a pattern of behavior that the state is unwilling and unable to, she didn't want to hear it. And, just had to say, I'm sorry you don't want to hear it, but this is what's going on in the country, right? This is the fact pattern that I, substantiate my research, and others have too. I think sometimes kind of perhaps a bit more frequently with attorneys, particularly attorneys that have never done an asylum case before, right? Asylum law is super complicated. And if you're a tax attorney, right, or if you're some other type of litigator and you don't have experience in the courtroom, it's like no other place. It's really a special place. And so I think when the judges take over the questioning, or when the attorney has a theory of the case that then kind of reads the room and then wants to shift the theory mid examination, right? And I'm not necessarily on the same page, or I don't know what's going on, or get asked questions that I can't substantiate in a way that's going to be supportive to the client. That's really challenging. Obviously, I can't perjure myself, so I'm going to answer it in a way that is factually accurate. But again, I think that having clear communication early and often is helpful to avoid those types of experiences. But yeah, it's typically the ICE attorney, the DHS attorney, and the judge, I think, that kind of throw experts off, asking about their Twitter accounts or how they're biased or advocates. And so I think just being sure that you've prepared your expert to answer those questions is really helpful.
Thank you. And Dr. Symes, you threw in some positive experiences along with the negative. Dr. Heidbrink, do you mind talking about a positive experience you've had in the same vein?
Sure. Maybe I'll kind of highlight a few positive elements, right, of different cases. I think one of the best experiences I've had overall has actually been with CGRS attorneys who just are amazing, right? They're amazing people, they're dedicated, they know the law, right? I may write things or use certain language that, knowing the judges or knowing the law, they're going to catch, that are kind of unintended. I recently served as an expert in a case in front of a judge in Mississippi, right? And Mississippi, I think, has like maybe a 1% grant rate. So they knew it was going to be hostile. They knew the judge, and they read my declaration and made suggestions based on knowing the context, right? Both the idiosyncrasies of the judge, but also the district in which kind of that case law is embedded. So those things were incredibly helpful. You know, I think one of the two other things. One is that, you know, from accompanying folks in court kind of prior to serving as an expert, particularly when there's telephonic or WebEx testimony, it can be really disorienting, right? That you hear a voice kind of beaming through the walls, right, in a language you may or may not understand, that may or may not typically is not interpreted for you. You don't know what the expert is saying. And it can be really disorienting, particularly for folks that might have had psychotic episodes or other types of kind of hearing voices or hallucinations, whether for psychiatric reasons or cultural reasons, right? So making sure that you've oriented your client that, okay, this expert is coming in over the telephone. This is what she's going to say. This is what she's going to testify to. If they don't speak English. If they do speak English, it's also really difficult to hear some of what we're testifying to, particularly psychological and forensic experts, I think, too, right? Like to have if it's your therapist, right? Your therapist talk about you in this kind of distanced way. I think experts, probably country conditions experts to a lesser extent. So I think, you know, for me, the positive experiences have been when the applicant has really been oriented to the process, to what's going to be said, how it's going to be said, to legitimize their feelings. And then I'd say one other kind of really positive experience I've had, you know, again, I mentioned that I typically only take cases in areas where I work. And so, you know, spending 3 or 4 months a year in Guatemala, I may be preparing a declaration in a town that I visited yesterday, right? So I've actually been able to visit with family members, right, or to transfer documents, right, that the attorneys need because I'm physically in the town or I'm physically nearby. There are obviously safety concerns and precautions that we have to take, but I think when you're able to make those types of connections, again, pretty unique. I think that was something I think that was really powerful, and ensuring that again, every expert's different, but I like to know what happens in the case. I like to know how the person's doing. I like to know if they've been granted, if you're appealing. Sometimes folks will, you know, send me a box of candy to say thank you, or sometimes I'll send a note to, like, you know, check in and see how they're doing, even if I haven't met them. You're bound together in this really traumatic process, right? And so I think those types of interpersonal connections are really powerful.
Thank you. And as a reminder, all attendees can submit questions via the Q&A feature on the webinar interface. And I will start off with a few questions we have. Why would somebody want to use a universal expert declaration rather than an individualized expert declaration? What are some of the reasons?
That's a great question, and I'm glad we're getting to it because I meant to say more about it earlier. I think, so one is just a note for people to be aware that there are such things as universal expert declarations, and they're a really good option, especially on this expedited time frame of the dedicated docket. when it may be difficult to obtain an individualized expert declaration. It might be hard to find an expert who can work with you on the time frame that you have. So the main difference between them are individualized declarations are tailored to a client-specific case, and they provide an individualized assessment and evaluation of the case or of the facts. And universal declarations, meanwhile, are not targeted to specific cases. So they can be used in cases, again, where you are just not able to get an individualized declaration for financial reasons or timing reasons. But they can also be submitted in addition to individualized declaration to add corroboration or to further flesh out the record. Universal declarations can increase access to expertise, and they're much more efficient. So for example, CGRS provides a number of them. They are listed in the materials for this webinar, so I'd invite folks to take a look and see if there are any that might be relevant to you. They're also available through our technical assistance program, and again, instructions on how to access that are included in the materials for the webinar, so I won't go into detail on that. But I would just say universal declarations can be a great starting place for research because they have just a wealth of information in them. And then they also can be used to give, for example, country conditions information that is hard to find through, your own basic research efforts. Universal declarations should, in most cases, carry more weight than regular country conditions reports. In large part because of the background and the expertise of the expert who is writing them. So for all those reasons, they're a really great resource to think about for cases generally, and especially for dedicated docket cases. One note is that generally, or probably universally, authors of universal expert declarations are not going to be testifying in court. There have been challenges raised to universal expert declarations for that reason. However, there are a lot of arguments that can be raised against that. So typically universal expert declarations are going to have a ton of information about the expert's qualifications. The ones that are available through our technical assistance program are folks who are very highly qualified, who have a lot of experience, and in theory, the information that's provided in the declaration really should speak for itself. I also just will mention, in the interest of leaving time for other questions, that we have, there's a recorded webinar available through our technical assistance program that goes into quite a bit of detail on how to use universal declarations for your cases. And so I'd invite folks to look at that, especially when considering, what might be some pushback that you might get from the government on using that type of declaration. And just to say, some examples of topics for universal declarations would be issue specific. So we have declarations on child abuse and domestic abuse, giving information on, why, root causes for those things. We also have psychological universal declarations that give information on, for example, the impact of trauma, which, for example, if you are not able to get an individualized psychological evaluation for your client, it still would be really helpful background for an adjudicator to have. And then we also have country conditions declarations on a variety of countries and topics. So again, I won't go into more detail in the interest of time, but please do reach out to us for more information.
Thank you. Thank you for that. And Dr. Symes, you had mentioned earlier that sometimes you collaborate or you find other potential collaborators in immigration cases. Could you just expand a little bit more on that?
Yeah, one of the really fascinating things that came up was that as we were interviewing our clients, we decided to go ahead and keep a database of all the clients that we were seeing, mostly for quality improvement initially. We actually did a consent up front to make sure, again, that it was de-identified and safe and all that stuff. We started noticing a lot of physical complaints from individuals, headaches, backaches, muscle aches, and pains. And then when we went back and looked, we found that similar reports had been, reported for individuals who've been victims of domestic abuse, for instance, right? So in our asylum seekers. And so we were able to collaborate with a headache expert here at University of Miami and work on a database research project that focused on, 60% of our individuals will actually have headaches as a manifestation of post-traumatic abuse and disorder. So that was one example. We've also worked with individuals on issues surrounding climate change and housing and work-related opportunities, right? Even if you don't have a work permit. So we get drawn into lots of accessory, conversations because of the issues that surround our clients. So.
And Dr. Heidbrink, I think there was, hear me? And Dr. Heidbrink, I think there was a resource that you knew about that you wanted to share.
Yeah, we put it out in the chat, but there's a new regional expert paper series through Columbia University's Center for Mexico and Central America, and it is a new but growing resource, often of country conditions experts who are writing on emerging issues in Central America and Mexico. So that's also a great resource for country conditions by researchers who are on the ground doing work. We're also, through that initiative, translating documents from Central American and Mexican researchers and research institutes. So things that typically have already been published in Spanish to make it accessible in English so that you could use that and present it to a judge already translated, because we recognize that that costs a lot of money, right, to translate documents. So that's a resource.
Wonderful. And that, unfortunately, is all the time that we have today. But before I leave, I ask that all attendees who want CLE credits stay connected for instructions to how to get your CLE certification. Also, please wait for the evaluation to come up on your screen. And to our fabulous faculty for this program, Annie Dare, Dr. Lauren Heidbrink, and Dr. Stephen Symes, thank you so much for sharing your expertise and your time with us today. On behalf of the ABA, I'm Emily McCabe, thanking you all for joining us. And I will now turn it over to Diana for some additional information.
Thank you, Emily. Ladies and gentlemen, on behalf of the American Bar Association and the ABA Commission on Immigration, we thank you for participating in today's program. To learn more about the sponsors, please visit the ABA website at www.americanbar.org. Thank you, and please click on the evaluation link. We value your feedback.